systematized approach could help the job also of the legislators, the practitioners as well. Therefore, I think that this initiative of these persons, these idea makers, I think it's quite useful for us as well. Therefore, I'm absolutely curious what can be the end of this procedure. Thank you so much for your presentation, and I'm waiting for your written contribution into the monograph.
Yes.
After that, dear colleagues, I would like to continue this opening seminar with my presentation. First of all, now I try to do my best. Where is the screen sharing? My question is whether you can see or not my presentation. Thank you so much as to your reactions. I would like to refer to the fact that some weeks ago, I focused on potential international aspects of the topic, and I tried to refer what should be the position of the Polish and or Hungarian decision makers in connection with this international development. Now I would like to, as you can here, you can see, the previous opening seminars topic, the Food and Agriculture Organization of the United Nations voluntary guideline and or regional human rights or international investment law regimes. And during my last presentation, I also referred to another potential aspect of international law. This is EU law, taking into account that EU law can also be considered as a kind of specific part of the international law. During my presentation, I referred that I would like to detail the EU law part during the third scientific seminar. That is the high time to do that. Therefore, in my presentation, I would like to focus on EU law aspects of land acquisition. First of all, I would like to refer to some soft law documents of EU law. I think it's quite important to emphasize that in the last years, some EU soft law documents appeared concerning land law. I have to draw your attention that this is a unique thing, because previously the land law issues, they were considered as an absolute nation or member state competence issues. I can recall, for example, a conference in 2015 in which also the representative of the EU Commission was invited. For example, I asked some questions concerning land law issue, what is the position of the European Commission, and in the reflection, in the reply of this representative of European Commission, he detailed that, he did not want to comment my questions because it is in the competence of the member states, and in generally the Commission did not have any, how can I say it, position in connection with this. They are waiting. They were waiting for the national decision, and they are going to comment this given legislation or measure. That's all. Taking into account this previous approach of the European Commission, I think this is a quite of interesting development as to this issue, that some European institutions in 2015 and in 2017 they adopted, determined, presented, issued some soft law documents. It's a quite interesting issue. What does it mean, soft law documents? In a given sense, I think that we have to consider these documents as quite serious documents. However, they are soft law documents, but especially via the judgment, for example, of the Court of Justice of the EU, they can become quite hard documents or law documents, and they can become part of the reasoning of these court decisions. Therefore, they are important. In a given sense, they also affect the sovereign issues, the competence of the member states. Therefore, I would like to draw your attention that there is some quite serious developments as to the EU level, and it is an important issue. Now, I do not want to go into details, but maybe in the written contribution of my research, I'm going to deal with this aspect of the developments as well. Therefore, there are some interesting soft law documents as to the national law and their relationship with the EU law. As to the primary law sources, especially in connection with the acquisition of ownership of agricultural lands, these primary law sources, they were the most important documents. I have to emphasize, of course, the role of accession treaties of the member state or member states. It's worth noticing that especially for the new member states, including Poland and Hungary, these accession treaties, they determined quite important regulations. Therefore, they are significant for us. Of course, the Treaty of the European Union and the Treaty of the Functioning of the European Union, these documents are important not only for the new member states, Poland, Hungary, but for the old ones. They are in the core of this issue as to the EU level concerning agriculture land law. And as a kind of new development, the Charter of the Fundamental Rights of the European Union, it can be considered as also as a kind of important document, essential document for us. I noticed that as to acquisition of ownership of agricultural lands, the primary law sources, and of course the interpretation of these primary law sources by the Court of Justice of the EU is essential. But of course, the secondary law, it can be interesting as well, especially taking into account the new judgment of the Court of Justice of the EU. I would like to refer to the so-called COPSIA case. In a later part of my presentation, I'm going to detail it. However, you can find quotation marks after the denomination of the directive 2006/123. The question is that whether the decision of COPSIA, there is a change, a permanent change in the interpretation and reasoning of Court of Justice of the EU concerning agricultural lands, or it cannot be considered in this way, and it is only a specific one. This is a pending question. Now I cannot give a proper answer to my question. However, now I would like to present what is the situation as to the competence of the given member state, taking into account the EU law. Therefore, the question is the member states' competence to regulate the acquisition of their land. The standard questions, for example, in the last 2 decades, they were based on the treaty of the functioning of the European Union and the regulation in this treaty. There were 2 pillars of the regulation. The first pillar, it was a so-called negative integration model. And of course, as to this negative integration model, I would like to refer the free movements of the European Union. In the last 2 decades, this pillar as to the agricultural lands, the free movement of capital was determining freedom. On the other side, there were the so-called positive integration model. This positive integration model was represented by the CEP. It means that Common Agricultural Policy, and of course the regulation can be found in the Treaty on the Functioning of the EU. As to the negative integration model, there was a kind of demand that please their member states do not regulate, do not adopt prohibitions in connection with the agricultural land market. However, as to the positive integration model, this positive integration model provided a kind of opportunities for the member state to adopt some kind of prohibitions, barriers concerning agricultural land market. And it was a kind interesting challenge for member states to adopt a kind of a balance between these 2 models of integration. I previously referred to the soft law documents. I think the soft law document of the committee and the European Parliament, in a given sense, these soft law documents a little bit supported the positive integration model opportunities. However, as to the soft law document of the European Commission, as a kind of contrary, it supported the EU negative integration model approach concerning the land market. That was the standard, especially these 2 models and how to find the balance between these 2 models. It was the standard question also in the practice of the Court of Justice of the EU. However, after the adoption of Lisbon Treaty, it was clear that there is a kind of third pillar of this situation, it is represented by fundamental rights, and they are regulated in the Charter of Fundamental Rights of the European Union. These documents, these soft law documents, for example, also the Commission document, also refer to the fundamental right, especially for the right to property. And it's worth noticing that, for example, a decision connected to Hungary and the Hungarian law was based on right to property as to land law case. Therefore, for example, this decision in front of the Court of Justice of the EU, in my opinion, strengthened the position of fundamental rights as to land market. That is the reason why in the title of the present slide, I refer to the new trinity. That is, previously we considered the competence issue of the member states as a balance between two pillars, but nowadays we have to calculate with the third one as well. That is the fundamental rights. Now, this is absolutely the reality. As to the last development of this competence issue, land law, and European Union law framework, there is a new step, a new wave. It connected to the EU negative integration model, and I think now there is a kind of hypothesis, but nowadays we can see a kind of movement from the emphasis of free movement of capital into the direction of the freedom of establishment. This case, it was against, we can maybe say that, or against of Latvia. This is the COPSIA case, in which case the Court of Justice of the EU established its judgment on the freedom of establishment. Therefore, now there is a question whether there is a kind of change on the negative pillar concerning agricultural lands issues in the EU legislation or not. COPSIA case opened this question, or popped this question. And as to this case, this COPSIA case, there was another interesting aspect of this COPSIA case. That is, the Court of Justice of the EU also based its decision on a secondary law directive. Therefore, as a kind of conclusion, previously, as to land law issues, we focused on the primary legislation level of the law. After the COPSIA case, there are two questions. The first one is whether there is a kind of change in the negative integration model role of free movement of capital and freedom of the establishment. And as a kind of second question, whether the secondary law level of the EU law gained more importance in connection with land law regulation. Therefore, this is the tendencies now. And after that, after this general picture, I would like to focus on our debates with the European Union, taking into account that Poland received a longer period a longer temporary period as to land law legislation. Poland was not included into this first wave debate between the new member states and the European Commission. Therefore, I hope that it can be interesting also for Polish legislators and practitioners. First of all, it was an interesting aspect that the Commission initiated a general, first of all, investigation, not infringement procedure, but an investigation in connection with the new member states concerning their land law issues after the end of their derogation. It was interesting because a similar general assessment of land law regime was not initiated against the old member states. Therefore, it is a question whether this can be considered as a kind of discrimination or not. Maybe we can say that it was only, sorry for the hard word, against the new member states. As I previously mentioned, Poland was not part of this issue at that time. Taking into account that this land law issue was part of the new member states' negotiations, because it was not as important question before the new member states. This question was not part of the accession treaty of the Austria, for example, but it was part of the new member state accession treaties. Therefore, making it can be a kind of answer why European Union initiated this investigation only against the new member states. However, there is another question, taking into account that during the accession of the new member states, for example, the old member states, they have a fear as to the free movement of persons, and therefore they also use derogation. But the European Union, the Commission, did not initiate a similar investigation against the old member states concerning the free movement of persons. Therefore, sorry, I'm a professor, therefore I may make this conclusion that, in my opinion, it was a little bit discriminatory step, that only the new member states were subject of this kind of investigation after the derogation time. Okay, and this, after the assessment, after the pilot steps, it's worth noticing that against some member states, the Commission initiated general infringement procedures. Slovakia, Bulgaria, Latvia, Lithuania, and Hungary, they were part of this general assessment. As to Hungary, because there were the most important, or there were a huge amount of critics against Hungary. During the pilot phase of this procedure, there were some measures adopted by Hungary which were accepted by the European Commission. Therefore, there were some positive aspect of this pilot period, that there was negotiations between the Commission and Hungary, and we together could solve these questions. However, there were some aspects of the new Hungarian legislation which were criticized by the Commission, and they are the subject of the infringement procedure. I would like to emphasize one important aspect of this infringement procedures. That is the Hungarian legislation, which includes a complete ban on the acquisition of land by domestic and foreign legal entities. I think this regulation is in the core of the Hungarian legislation. This is a conceptual part of the Hungarian legislation. However, there were other criticized provisions of the Hungarian legislation. You can see them here. As to Hungary, now focusing on Hungary, there is a pending, because it was, as you can see, initiated in 2015, but this is a pending infringement procedure. But there was another case. This case, this is a specific part of the Hungarian legislation. This is connected to a usufruct issue that is in the Hungarian legislation. There is a kind of cancellation of the registration in the property register of the usufructuary rights in agricultural lands. Of course, I would like to detail this specific issue also in the monograph, in my chapter. But in connection with this, the Commission also initiated a specific infringement procedure. And it's quite important factor that not only the Commission, but other affected parties in front of the Hungarian constitution, in front of Hungarian courts, and after that, via this Hungarian courts, in front of the Court of Justice of the EU, these parties also initiated procedures against the Hungarian legislation. They are the Segro case, the Grossmania case, and so on and so on. All of them connected to a given aspect of this specific part of the Hungarian land law. In my opinion, this issue, after these preliminary rulings and specific infringement procedure, can be considered as a closed case. The Hungarian legislator adopted a new law to solve this case. Therefore, as to the future, I do not calculate with other important preliminary rulings or infringement procedures this usufruct case. For me, the question, of course, maybe the other aspect of the Hungarian land law, and of course the so-called general infringement procedure, which one is pending. After that, maybe the question is, especially taking into account the Hungarian legislation approach, that is, we would like to protect our lands. And I think that is taking into account the characteristic of the Polish legislation. I think the Polish legislator has a similar approach as to the lands. The question is, how can these countries, Poland and Hungary, keep their competence to protect their land market against the speculation, for example, against the phenomena of land grabbing, for example, and so on and so on. This is a question. In connection with this, during CEDR conference, I was a general reporter in a CEDR conference workshop. At that time, I tried to determine the potential ways of development. It's worth noticing that it was not accepted by the working team, the research team of the Potsdam Commission, because there was a huge debate among the lawyers, especially the lawyers from Western countries, and especially the lawyers from Hungary. However, Polish partners, they also attended this panel, but they were not as active in this debate. But as to the end of this debate, there was not a conclusion of the research team, but of course I made my own conclusions in connection with this. What could be the potential directions of the development? The first potential direction, that is, the EU sees to apply the 4 fundamental freedoms with regard to the land policy of the member states. It is a question, some colleagues, Hungarian colleagues, they think that they thought that it can be the end of the European integration. Another issue that member states, Poland, Hungary, they liberalize the rules of their land market. This is also an option, you know, that there is a freedom in this issue. Another potential way to solve this debate merely at political level. However, it's worth noticing that this merely political solution without a legal modification amendment, it does not protect against the preliminary procedure. Therefore, it's only a partial end of the debate. And another option that is a move in the direction of further regulation, even modifying the primary legislation of the EU law. It was they are the potential ways. Later, however, in a Hungarian forum, we also dealt with how to we also dealt with the potential opportunities. Some of the Hungarian professors, they presented kind of solutions. For example, via the renationalization of the CEP, the Common Agricultural Policy, it can be a kind of solution. Or we can protect our land market via a stricter EU's rural development and environmental protection regulation. Therefore, maybe these stricter rural development and environmental protection regulation, maybe they could provide a broader scope for the member states to regulate their land markets. There were some ideas that the movement from the free movement of capital concept as to land market issues of the euro towards the right of establishment, as we can see the COPSIA case, this is a kind of movement from this part, or the integration of the land acquisition into the CEP. There were some ideas that maybe via the rethinking the scientific background and this effect on the practice of the Court of Justice of the EU. This is the reality. However, my final initiation is, I know that it's not the Eurasian Economic Union. This is a Russia-based union. However, as to this Russia-based Eurasian Economic Union, you know, it's also about the common market on 4 free movements as well. And in this union, the member states are able to apply a reservation in connection with the agricultural land market. It means that it is not part of the free movements. In my opinion, it's also a kind of option. However, it's worth noticing that, as I previously mentioned in connection with Potsdam, in the first point, that maybe it can also mean the end of the European integration. Therefore, this is a question. It's not a solved problem, but there is a framework. And of course, in the monograph, I'm going to focus on these issues. Thank you so much for listening. I was honored by your attention, dear colleagues. And now my end of the sharing, and I would like to provide for my colleague, and I would like to call her Dr. Hornyak, who is going to deal with another interesting aspect of the legislation as to the holding approach and agriculture market. There, Doctor, the screen is yours.
Thank you very much. My first question is if you see my presentations.
Definitely, it's okay.
Thank you. So, as Professor Szilágyi said, I would like to speak about some special rules for agricultural holdings in Hungary. But today I will not end this thinking about this problem or about this area because in my writing chapter, so I would like to discuss a little bit more about this topic, and not the next one, but the after the next. So I think in August, so the Open Scientific Seminar in August, I would like to speak about a very actual question for Hungary, which is in a strict connection with today's topic. So I would like to say that the presentation today will end a little bit later, and today I would like to highlight some questions and problems about the regulation in Hungary. I know that on my first presentation in the first Open Scientific Seminar, I already spoke about the fundamental law of Hungary, but today I have to mention Article P because for the topic of agricultural holding, there are some very interesting questions in the regulation of the fundamental law. As you can see on the slide, so Article P and subsection 2, I doubled this section 2, because the first one is the text which is in force today, and the second one was the text of the regulation between 2012 December and April 2013. And this section says that Hungary has an obligation to make an implementing act in 3 areas. The first one is the land transaction area. The second is the organization of integrated agricultural production. And the third one is the family farms and other agricultural holdings. So the regulation about this topic. But the family farms is in the text only from 1st April 2013. And I think it's not a coincidence. And I would like to highlight what I think, why is it in the text now, and why it was not in the text in 2012. So as you can see in the slide, there are some acts in green color and some acts in red colors. And this color means that the green colored acts are now exist, but the red colors, the red color mean that these acts does not exist now. So as you can see, we have Land Transaction Act. We have a secondary act to the Land Transaction Act. We have already a Family Farms Act and an act on transfer of agricultural holdings. But we doesn't have a full, coherent, complex act on agricultural holdings, and we have not so we haven't got an act about the organization of integrated agricultural production. But I have to mention that Act on Family Farms and Act on Transfer of Agricultural Holdings have some kind of rules about the agricultural holding system, but I think we cannot say that Hungary has a regulation about agricultural holdings, and this is my hypothesis in this field, that we doesn't have an agricultural holding regulation, but we have some rules about the agricultural holding. First of all, we have to see that in agricultural law in Hungary, so in the basis of the Hungarian regulation is the agricultural land. But in the Western European countries, in the basis of the regulation is the agricultural holding. And in Hungary, as I already mentioned, we doesn't have a whole coherent, complex regulation on agricultural holdings, but we already have an Act on Family Farms, and I will determine that what I think, where is the family farm in this system. And we also have an Act on Transfer of Agricultural Holdings, but it's really not a holding regulation because it's only for one case. So it is for the for helping the changing the generations. So it's only a very special category, and it means a very special contract. So this transfer of agricultural holdings. So I think we doesn't have an agricultural holding regulation in Hungary. Only we have so in the transaction we are regulating the transaction of agricultural lands, so the transaction and the acquisition of ownership of agricultural lands, and not the holding. And I would like to speak about a little bit about these four acts which already exist in Hungary. These acts are partly implementing acts or fully implementing acts, and all of these four acts was already exist, have some definition about the holding, and the category is very different, and the name of this category is different in this act. And of course, the whole definition is a little bit different. As you can see, the Land Transaction Act has a definition of the agricultural holding, and until 1st January 2021 has a family farm definition also in this act, but today is it not in force anymore. And the situation is the same in the secondary act to the Land Transaction Act, because the family farms definition is in this act, or was in this act till 1st January 2021. And we have some new acts since 2020 and 2021. So the Act on Family Farms, in this act we can see the own holding definition, and the Act on Transfer of Agricultural Holdings we can see the definition of holding. And I would like to show these definitions in a comparative approach. So first, we can see the Land Transaction Act's definition and the secondary act to this act, so the definition of this act. And I already mentioned in the first Open Scientific Seminar that the agricultural holding, according to the Land Transaction Act, is a basic organization unit of production equipment and other means of agricultural production, operated with the same objective, functioning also as a basic economic unit by way of economic cohesion. And it means that it's a group of things in this case. The definition of the family farm was till 2021, the family farm was a type of an agricultural holding, which are registered as a family farm. But it was the main category that is a type of the agricultural holding. And the definition of the family farm in the case of this other act, of the secondary act to the Land Transaction Act, said that family farm is until the entry into force of the implementing act on agricultural holdings. This family farm means a group of land owned and used by the members of the farming family, as well as immovable and movable properties belonging to the land and identified in the inventory, the use of which is according to the contract between the members of the farming family is based on the full employment of one member of the family and the contribution of the other members on the family, and which was registered by the agricultural administrative body as a family farm. But this definition now is not in force since 1st January 2021, because the act on family farm is entering into force in that date. And now we can see that the main definition of holding is how it seems in Act on Family Farms and the Act on Transfer of Agricultural Holdings. So the name of the category is a little bit different. Act on Family Farms, we can see the own holding category, and the Act on Transfer of Agricultural Holdings, we can see the holding category. And the first definition, the own holding, is in force from 1st January 2022, but the holding, the definition of the holding according to the Act on Transfer of Agricultural Holdings is in force from 1st January 2023. But we can see these definitions are very similar, but in this act, in this Act on Transfer of Agricultural Holdings, it's much more detailed, this category. So the Family Farms Act says that own holding is an agricultural and forestry land in the natural person's own use or the common use by the members of a family farm of small-scale farmers, as well as the range of agricultural production tools for which the concerned person or persons are entitled to organize the production, as well as the right to use the results of production. And the other category, according to the Agricultural Holdings Transfer Act, is the holding, and we can see that it means the agricultural and forestry land, including farmstead, owned or used by the transferor of the holding. This category is very detailed. The transfer of the holding is a very detailed category in that act. But today I don't want to speak about it because it will be the question of the future according to my research. And then I have to continue the definition. So we can see that we can mention the other immovable properties owned or used by the transferor. Other movable properties is the same, owned or used by the transferor of the holding. And rights in rem in respect of agricultural and forestry activities belonging to the transferor of the holding. Other category is a share in the assets of a business association related to the agricultural and forestry activities carried out on the holding, a share in a cooperative society, or a corporate interest in an association of forest holders. And the last one is the rights and obligations relating to the assets set out in the previous points. So it's much more detailed, this holding category, as I previously mentioned, by the Family Farms Act. But I would like to speak a little bit about the Act on Family Farms and a little bit about the Act on Transfer of Agricultural Holdings. Not so detailed, but I would like to highlight that why I said that I try to characterize this category of family farms, that how can I in this system said that family farms is here or here in this system according to the fundamental law of Hungary. Because the Act on Family Farms determines the category of the own holding, but after that, this act focuses three definitions, three categories. And as you can see, the agricultural small-scale farmer is one of these three categories, who is a natural person. But the other two categories, the family farm of small-scale farmers and the family agricultural company, is such a group of peoples, but a very different way. Because the family farm of small-scale farmers is not a legal entity, but the family agricultural company is a legal entity. And I think it makes a little bit confusing by this whole agricultural holdings regulation. But first, I would like to speak about these definitions, because this the so-called agricultural small-scale farmer is a natural person who has reached the age of 16 and who is listed in the Register of Agricultural Farmers, and who carries out his farming activity on his own holding. And this an agricultural small-scale farmer may carry out his farming activity either independently or as a member of family farms of small-scale farmers. And it's a really important condition that an agricultural small-scale farmer may not be self-employed in respect of his small-scale farming activity. And when we speak about the family farm of small-scale farmers, we can say that this is a production community established by at least two agricultural small-scale farmer members in a chain of relatives without independent legal status and no assets separate from the members' assets, within the framework of which the agricultural farmers carry out their farming activities jointly on their own holding and in a coordinated manner based on the personal contribution of all members. So it's not a legal person, it's at least two agriculturals. It means at least two agricultural small-scale farmers who are relatives. And very important condition that an agricultural small-scale farmer can be a member of only one family farm at the same time. And when we speak about the other category, this legal person category, so the so-called family agricultural company is a business association or a cooperative society or an association of forest holders entered in the Register of Family Agricultural Companies, which is engaged exclusively in agricultural and forestry activities or secondary activities as defined in the Land Transaction Act, and which has at least two members and whose members are related to each other in a chain of relatives. And here I can see also that a person can be a member of only one family agricultural company at the same time. And a legal person cannot be a member of a family agricultural company, except in the case of acquiring its own business share or its own share. And what was in the background of the Family Farm Act? In the justification, we can read that this Family Farm Act summarizes common efforts in the fields of tax policy, agricultural administration, and farm restructuring. And the purpose of this act was to contribute to the whitening of the economy and to reduce administrative burdens and to encourage horizontal and vertical cooperation and to strengthen the market bargaining position of producers and to improve competitiveness. But my question when I examine this whole act, that actually this family farm, what it is in concreto. It means a farming structure, a production community, a form of operation, because the justification of the Family Farm Act and also the text of the act is a little bit different, and in the different category there are such a wide range of the categories. So I am not sure that this regulation can help the Hungarian agricultural holding regulation, and this this category, what we said in the Western European countries, that this is the agricultural holding, and the transaction of agricultural holdings are regulated in this way. So it's not clear to me, and I think we have to a little bit clarify these categories in our regulation. But of course, it's only a question from me, and now I am writing this chapter, so maybe in the next months I will be a little bit concrete, much more concrete in this question. But what is this Act on Transfer of Agricultural Holdings? I don't want to speak so detailed about this act, but you have to see that this act is taken to force from the 1st January of 2023, and the purpose of the act is to help this whole unit, so the transaction of the unit to the next generation, and it means that that the parties have a relation to each other, and the elder farmer wants to transfer his whole agricultural holding to the younger farmer. And there are 4 types of contracts or which contracts can the transferor make this this whole transaction. But I would like to speak more detailed in the future about this contract. And I would like to mention the Hungarian Civil Code, because we have one article about the agricultural holding, and it's a very special article because it's in the succession law, and it says that the heir shall be entitled to separately disclaim inheritance of a farmland and or its equipment, accessories, livestock, and tools and implements if he is not engaged in agricultural production by profession. So these assets can he disclaim together in a unit, and this unit category is the agricultural holding. So I have to mention Mihály Kuruc, who is a Hungarian professor who is dealing with this agricultural holding and category and the regulation and the possible regulation of agricultural holding. And he suggested that the agricultural holding can be regulated in two ways in the regulation that also affects land transaction. The first option is to regulate the agricultural holdings on the basis of a material concept of the totality of things or the totality of assets. It means a category of Betrieb. It's a German word, but it's very good for this category. And the second option is to regulate holdings on the basis of an enterprise approach, and it means the Unternehmen. And he said that for enterprises that are not structured and do not have legal personality, this Betrieb category, this Betrieb type of regulation could be a solution. And in the case of enterprises with legal personality or organizational structure, the legal framework is determined by the legislation already. So maybe in the company law rules of the Hungarian Civil Code or other nation civil code. So it means there is no need for a separate enterprise structured regulation. And when we see the Hungarian regulation and this opinion, we can say that the holding is the group of things. It means a set of several separate things that serve a common economic purpose and that's included in transaction as a unit. So it means the immovable and movable properties, and the land is only a part of it. So I think this so-called Betrieb type and the Betrieb regulation can be good for the Hungarian legislator, and we have to a little bit clarify this whole holding regulation in Hungary if we want to move forward, and we say it's only the first step for the Hungarian holding regulation. Because we have a land transaction regulation and the land is only the part of this whole unit, and we have to keep this whole unit, this whole group of assets and things together, and it's very important against the fragmentation. But I would like to examine this whole transaction of the agricultural holding in the future, not only inter vivos, but mortis causa as well. And after that, I would like my conclusion. After that, I would like to say my clear conclusion. Now I would like only the questions what I mentioned before, and this is at this point my opinion. And next time I will be a little bit, I hope, much more clear in this question. And thank you very much for your kind attention.
Dr. Hornyak, thank you so much for your contribution. I'm waiting for your next step presentation. Please do not forget that hopefully it's going to be happen in July, not for you also, but for others. As far as I know, and I checked the date, it is 26th of July. It is on Wednesday. But now we would like to continue our open seminar with the presentation of Dr. Strela. Dear colleague, the screen is yours. Now we cannot hear you, dear doctor. I think it's muted, or I don't know what is the situation. Now we cannot hear you. Maybe it is muted on your computer. I don't know what is the situation, because and now no, we cannot hear you. Or maybe other colleagues, can you hear, Dr. No, okay.
And now maybe?
It's perfect. It's perfect.
Okay, thank you
Okay,
very
thank
much.
you so much.
I'm very sorry for the delay, probably some internet connections issues. Thank you, Professor. Okay, so I believe you can hear me, and I would like to ask once again about the presentation. I'm sharing the screen. I assume that you can see it.
Yes, definitely, it's okay.
Okay, thank you very much. Dear Professor, dear colleagues, and dear participants, I would like to talk today about the two important legal institutions of Polish law in the field of the transactions on the agricultural land. Right to acquire and the preemption right to agricultural land in Poland. To start with some preliminary remarks as a context for the next slides. Previously in the first seminar and the second seminar, I talked about the main regulations of the Polish law from 2003, in abbreviation UK UR, which is important in the version from the 2016. According to this law, only individual farmer can be owner of the new owner of the agricultural land. There are some exemptions. However, there are few exceptions, and they are of minor importance for acquiring agricultural land by legal entities. I would like to underline that mainly only legal entities that can acquire agricultural land without the permission from the authorities are the churches and other denominational legal entities. So this first regulation presented in detail previously on the second seminar, you may say they are the first pillar of the restrictions about the transactions dealing with agricultural land. The main pillar, the most restrictive law, the main hurdle, high hurdle to acquire agricultural land. But even if someone is an individual farmer and formally can acquire agricultural land, even according to this restrictive law in the version from 2016, in many cases, he or she won't be able to acquire that land. It is because there is a second regulations, we may say second pillar of the restrictions in the transactions about the agricultural land. It has these two rights: this right to acquire agricultural land and the right and the preemption right to agricultural land. In fact, these two regulations, these two legal institutions are very similar in the effects, but theoretically they are different. The main, you may say in Latin, criterium divisionis, or the base of differentiation of these two institutions, is the kind of the legal event that results in the transfer of agricultural land, resulting in the change of the owner. As far as right to acquire agricultural land, this right deals with other than sale contract events, and the preemption right is concerns especially only sale contract. So to start with the first one. The first one, the right to acquire agricultural land. In the Article 4, Paragraph 1 of the UK UR, there is four categories of legal events that result in the right of the national center. This is the legal entity of state which deals with agricultural land mainly. The right to acquire the land which normally will be transferred to the other person. This For legal events is the contracts other than the sale contracts, for example, donation contract or the switch contract, which is not a sale contract according to Polish law. The unilateral legal act, it is important that in Polish law, donation isn't treated as a unilateral act. In the donation contract, we have two parties, but one is legally taking obligations for transferring ownership to the other. So this second point doesn't deal with the donation contract. The third category is a court decision, other decision, especially in the execution proceedings. And the fourth, very interesting category is any other legal event. There are some examples given in this statute, particularly acquisitive prescription, which is very important because after 10 or after 20 or 30 years, someone can acquire ownership because of only of its use for this period of time in Poland. Another examples are the administrative proceedings for division of the plots, transformation of the plots, and this is the transfers that are done in the administrative proceedings before the authorities. And in these four categories of legal events, National Center, which is the abbreviation for the in Poland, the abbreviation is KOVR. It can be translated as a National Center for the Support of Agriculture. This body, this state body, simply can make an declaration of will, and after this declaration, the ownership goes to this national center. This is the main characteristics of this right to acquire agricultural land. What is important, this regulations applies to in the case of the acquiring shares in companies that owns more than 5 hectares of agricultural land. So when we buy a share in the company, we should examine whether the company owns agricultural land, because there is a possibility that we won't acquire agricultural land according to the, for example, sale contract of the shares. What's the most important regulation, I believe, the most practical regulation in this field, are the regulations about the price, because when someone sells the agricultural land, for example, in the switch contract, or there are some sums that goes, for example, to make the difference between the value of the two plots. It is he or she is interested in gaining the money. So what's the regulation? According to the law, if price is not determined, for example, there was not determined in the course of the administrative proceedings for the public sale of the land, the price should be calculated according to the legal provisions in other Polish law. This is the law about the real estates. And there are 3 or 4 kinds of the appraisals for the calculating price. They differ in the high amount in the result. For example, calculating the transfer prices normally presents the real value, real economical value of the land, and the other form of the appraisal, for example, appraisal that calculates the money need to rebuild or of the buildings. Normally it's lower than the real economical value. So this is very important in practice, which method of calculating price will be chosen. And there are, of course, there are exemptions. There are some exceptions in these regulations. Mainly, this is the acquiring agricultural land by the close relatives, for example, brother or sister of a descendant. Other exceptions deals with inheritance, and as you may remember from the previous presentation, the main possibility for acquiring agricultural land by the legal entity is in the way of obtaining authorities permit. And when we got this authorities permit, we also are excluded from this right to acquire agricultural land. Other exceptions deals with enlargement of the family agricultural holdings or the transactions between legal persons, but this is important, not between any churches, but between the legal entities of the same church. For example, between the dioceses of the Catholic Church is okay, but when, for example, the parish of the Catholic Church would like to sell, would like to donate the agricultural land, for example, to the parish of the Evangelical Church, still there is a right to acquire by the National Center for the support of the agriculture. There is one article that made a reference to the regulation in the Civil Code about the preemption right. And this reference affected in the debate. There was some controversies about how to apply these regulations. Why? Because according to the regulation in the Civil Code about the preemption right, it should be done like this. A person who, for example, like to donate agricultural land should donate it, but conditionally. So in the contract before the public notary, there should be a condition that the transfer of the ownership will be in effect when someone entitled to this preemption right doesn't exercise his right. So the ownership still is with the seller on the condition that someone entitled by the preemption right doesn't exercise his right. And this is difficult in some ways because according to the, for example, how to make this conditional, this condition in the kinds of the legal event of acquisitive prescription, or in the donation contract, for example, when in Polish law transfer of the ownership of the real estate cannot be done under conditions. It must be unconditionally transferring of land. We can make an obligation, but the effect in rem cannot be restricted by any conditions. So there are some, this raised some concerns about how to deal it with practice. And what is the aim of the regulation? The aim is to enhancement the family holdings and this regulation about the authorities permit. The second institution is the preemption right to agricultural land, and this deals with only with the sale contract. And the rules are different from the previous one, because this preemption right is well, who is entitled? Only the tenant, or you may say lessee of the usus fructus contract of the agricultural estate, of the lease contract because this is the legal terms for this contract in Polish law. So when the lease agreement was concluded in writing, this is the first condition, the first prerequisite. Secondly, it must have a certain date. A certain date is a very specific concept in the Polish civil law, because the certain date is a concept when the date of the document is sure. For example, the document have a certain date, the sure date, after the death of a person who signed it. And this is another thing is the any notes done by the authorities on the document, maybe some confirming by the notary in public, and so on. And this is the second prerequisite. The third, the contract must be performed for at least 3 years. And what was new in this regulation after the modification in 2016, the agricultural property must be part of the family farm. So after these all prerequisites are met, we are entitled to preemption right to agricultural land. How it should be done in practice? Firstly, we cannot transfer the ownership at the beginning. We need to conclude, in fact, 2 contracts. The first contract is a conditional contract. As I previously said, it is done that the ownership will be transferred on the condition that the holder of the preemption right will not exercise his or her right. When, for example, the period of time when this right can be exercised, or the holder of these preemption rights make a declaration that he or she will not exercise his or her right, only then the seller can conclude the second contract, the contract in rem, which transfer the ownership to the buyer. There were some dispute whether the regulations about the civil code concerning preemption right to all of the assets, not only real estates, not only agricultural estates, applies in this case. In the 3 cases before the Polish courts, they all stated that the rules from the Articles 596 till 602 of this Polish Civil Code applies. So we need to go and look through the provisions of this part of the Civil Code. There are this first rule of 2 contracts, 1 condition, 1 unconditional of the transfer apply. The second one, that there's 1 month period to exercise of this preemption right. And what is far more important than all of this? Normally, when someone is entitled with the preemption right, concluding a contract in violation of this preemption right results in liability for damages. However, in some circumstances, the contract of the transfer of land or other assets is null and void. And the circumstances is regulated in the Article 599, paragraph 2 of the Polish Civil Code. And when this preemption right is granted not by the contract itself, but it is granted by the law, the public binding law of the state. The second thing, it is granted to the state treasury or the government unit, a co-owner or the lessee. The sale without this condition is null and void. In our case, in the case of the regulations on agricultural land, the preemption right is granted to the lessee, is granted by the law. So it results that selling without this condition is null and void. And what is, in my opinion, there's a one small paragraph of this regulation, but very, very important. When there is no holder of preemption right, when the law granted this right, but there are no lessee or the tenant doesn't exercise the preemption right, this preemption right goes to the National Center for the Support of Agriculture. So, in fact, in every case, the public institution has the right to acquire agricultural land because it's entitled by the preemption right. This regulations is complementary to the rules from the first pillar, because even when someone can buy or can sell the agricultural land, in many cases, not all, but in many cases, maybe probably the majority, public institution can regain control about this agricultural land, can buy it at paying the price, of course, but it can be acquired by the state institution. Summarizing, so even between the individual farmers, transport of agricultural land is still restricted. In the case of the sale contract, leaseholder or the tenant is protection by the preemption right. The aim is to make sure that the agricultural land will be used in the proper way, and when someone runs a farm for the 3 years, there is a presumption that for the next period he or she will be still running the farm, that has experience, and this is not buying for the speculative purposes. Violating his or her rights results in the declaring contract null and void. And when no entitled to preemption right, the national institution can acquire the agricultural land. And in any other legal event that could result in the transferring of agricultural land, the same institution, KOVR, is entitled with the right to acquire the land, with in the effect as the result are very the same as the preemption right. Thank you very much for your kind attention, and if you have any questions, I will gladly answer any of them. Thank you very much.
Thank you so much, and now I give the floor for Professor Adamus.
Just give me a second, please. I'm going to manage with some technical aspects of preparing my presentation. Just a second. Okay, I can start with my presentation, and I hope I will show you in just a second the proper text of it. I'm more than happy that I can continue my scientific research concerning protection of farmers. Today I'd like to change a topic of civil protection of farmers, and I'd like to jump into another issue concerning preventing insolvency of farmers. It's a very important issue because any person who takes a part in commercial activity is likely to be insolvent. There are many reasons which are responsible for such a situation, and I'm afraid you cannot see my presentation up till now. The problem is that something is loading on my screen, and I cannot show you my presentation.
Yeah, my question, but I think that Dr. Strela, I think he closed his own presentation. I hope so, but I think so.
Okay.
I believe I have cancelled the presentation. So
I still have something loading on my screen, and please wait just a second.
may I ask to add Professor Adamus as a presenter? Maybe this is the issue. I cannot done it by myself.
Okay. Now I hope. I have no idea what's going on, but probably it's something wrong with my connection, and because I only can see something, but it's something loading still. Probably. Okay, one more time. Okay, so I can start without presentation showing you by my screen. Sorry for that. I have some technical problems. I am not too smart to manage it by myself right now, so probably I can tell you something about my latest scientific research connected with insolvency. Well, of course, I'm going to come back to the first topic of my scientific research connected with civil protection of farmers. I think I can change the topic for now because there are so many interesting issues connected with preventing farmers' insolvency that I have not much time to present the results of my research. Of course, insolvency is a common commercial risk. Anyone who takes part in commercial activity is likely to be insolvent. There are many reasons responsible for such a situation. And thanks God, Polish legislation is at a very good level in the connection with insolvency problems. We have very modern legislation. There are so many proceedings to be chosen by debtors who are in financial problems, who are in financial distress. So I think that the legal aspects of protection of all entrepreneurs and natural persons are at a very good condition. But of course, always it could be something better than now. And I hope I could give you some examples of how to protect the farmers on a much better way than now. I think that there are some levels of possible protection of farmers. I think that we could start discussing the problem of protection before the threat of insolvency. The threat of insolvency is the premise of restructuring proceedings, and there are some ideas to protect farmers in such a level. Of course, before insolvency itself, there should be some changes in order to help farmers to manage with financial problems. And of course, there are many ideas how to change restructuring proceedings and bankruptcy proceedings in order to help the farmers to gain the effects of such proceedings in much better way than now. Of course, there are some issues connected with help after bankruptcy, especially connected with the problem of debt relief, which is very important for insolvent participants of the commercial market. Up till now, there are two main acts connected with insolvency in Poland. This is the Act of Bankruptcy Law dated 2003 and the Act of May 2015, Restructuring Law. Restructuring Law is a special act which helps entrepreneurs and farmers as well to avoid bankruptcy and enable them to make a settlement with the creditors in the shape of the arrangement, which should be proposed by debtor or other persons who are entitled to do this, and it should be accepted for precisely shown majority of creditors. And as far as we check the cases, I think that restructuring proceedings are much more better for the creditors and for the debtor as well, because there are many serious problems connected with bankruptcy. Bankruptcy gives a very small financial dividend for the creditors. The problem is that there are very late motions for bankruptcy, and in fact, it's very also expensive proceedings. I mean, bankruptcy proceedings, and it's better to the creditors and the debtor to settle some liabilities of the debtor in the arrangement which are agreed by the parties or the majority of the parties. Up till now, we have special rules for farmers' capacity in bankruptcy proceedings. And in fact, in respect of restructuring proceedings, the capacity of farmers who are natural persons are not limited. So it means that a farmer who is a natural person can choose any proceedings which are open to the debtors and can start these proceedings, which is the best for his situation. But in the shape of the bankruptcy proceedings, there are some special limits because bankruptcy goes often very far. The effects of the bankruptcy proceedings are very often very profound. That is the decision of the farmer if he would like or not to start such a proceedings. And in this respect, the farmer who is a natural person can start only bankruptcy proceeding for consumer, so-called bankruptcy proceedings. So I think that is a very good regulation that farmer is free to choose the restructuring proceedings which is the best for him. And in case of consumer bankruptcy, he is subjected to the special and very friendly proceedings connected with bankruptcy for consumers, and farmer is treated as a consumer in such proceedings. Of course, I'd like to explain that there is a very complicated tree of possible proceedings connected with insolvency. I think that we could say about bankruptcy proceedings for entrepreneurs. It's the general and main kind of proceedings in bankruptcy. And there are a couple of separate bankruptcy proceedings for special debtors. One of them are consumers, and in this respect, a farmer who is a natural person is subjected to bankruptcy proceedings for consumers. In case of restructuring proceedings, we have four main types of the proceedings, and three of them are under the regulation of the Polish law and the European Union law, and the fourth of them is subjected only to the Polish law because due to the restructuring directive, it is a possibility to withdraw some insolvency proceedings from the results of the insolvency directive. So in fact, we have three proceedings for debtors which are so-called preventing procedures. First is the proceedings for the approval of arrangement. Is a very flexible proceedings because the debtor can make an arrangement with creditors not in the court proceedings. If he file a motion to the court after the arrangement had been concluded, and it's a very flexible way of negotiating with creditors. And I think that the greatest number of insolvency proceedings are connected with proceedings for the approval of arrangement. The other two proceedings which are under Polish and European Union law are accelerated arrangement proceedings and arrangement proceedings. They are very similar. There are some small differences between them, but in fact, accelerated arrangement proceedings is a faster one and much more simple in the practical aspects of dealing with insolvency. And we have the other proceedings which are very special, the disciplinary proceedings. It's a very strange regulation because there are elements connected with bankruptcy and restructuring in one proceedings. And in this respect, I think that it is a kind of proceedings between restructuring and insolvency in the shape of bankruptcy. And of course, in such circumstances, I think that I could recommend some ideas for my research plan. I think that I could present my ideas for changing, amending the law into big parts. First, the short-term changes, which could be introduced very quickly, and long-term changes which should be carefully discussed, and after a careful discussion there should be proposed the rules of insolvency law in order to improve the level of protection of farmers. However, I think that on this level, I think that idea of quick simplification and facilitation of existing insolvency proceedings could be introduced very quickly. I think that in Polish law, motion for bankruptcy proceedings and restructuring proceedings is the most complicated and formal motion. And in fact, farmers do not collect so much data as entrepreneurs. And in some cases, I think that there should be less formal requirements for the farmers to start the proceedings before the court. I think that it will be very easy to introduce such changes in order to provide less formal requirements for farmers who are interested in insolvency proceedings. The next issue, I think, which should be discussed very carefully is the situation of a farmer who is a natural person after enforcement proceedings, because there is a very big gap between the situation of the farmer who is a natural person after bankruptcy, consumer bankruptcy proceedings, and a very great difference with the situation of the farmer after enforcement proceedings. Why? Well, in the case of bankruptcy proceedings connected with regulations for consumer, there is a special happy end for the debtor, and after the bankruptcy proceedings, after selling his estate by the trustee, it's possible for the debtor who is a natural person to get so-called debt relief. And in these proceedings, the court, after fulfilling special requirements, cancels all liabilities of the natural person. So in such circumstances, it's very friendly for natural persons to start bankruptcy proceedings to lose all the estate, of course, but to finish the proceedings with no more liabilities to any of the creditors. In fact, in case of enforcement proceedings, there are not such facilities for the farmers, and the farmers are remaining with all the liabilities which are not covered by the money got from enforcement proceedings. And I think that we should to rebuild the regulation and eliminate the gap between these situations of bankruptcy and enforcement proceedings, because they are not equal, and this indifference is very problematic for the debtors. Of course, there are many other concepts which could be presented. As I mentioned before, there is a general proceedings for entrepreneurs, and there are specific kinds of proceedings for special kinds of debtors. I think that we should introduce into the law a separate insolvency proceedings for farmers, because the situation of farmers are very individual comparing with the situation of other debtors, and some institutions which could help insolvent farmers could be better presented in a special separate insolvency proceedings. However, there are so many problems with the system of justice in Poland connected with a very big influx of new cases to the bankruptcy courts. Due to the statistics, there are 220 bankruptcy judges in Poland, and the number of new cases connected with bankruptcy of consumers could be counted in thousands and thousands. So in this respect, I think that we should try to change the philosophy of the law in this respect. The idea is to allow the proceedings to go on if anyone does not oppose to the next stage of the proceedings. And in case of a situation in which someone is going to object the proceedings, the court should be in its reaction in such a case. So in so many situations that there are no problems for consumers which are debtors, and there are no problems for the creditors, I think that the proceedings should go on automatically, and the court should stop only in the case if somebody is going to file objection to the proceedings, which should go on automatically. I think that this change could be prepared very quickly, and I think this is something to be discussed in a very careful manner. I think that there are much more other ideas connected with bankruptcy proceedings and protection of farmers. I think that we could discuss some more details connected with insolvency. For example, in case of the situation in which we have so-called rebus sic stantibus clause. So in case in which the farmer concluded with his creditors the arrangement, something during the fulfilling the arrangement happens which does not allow to the farmer to continue paying the creditors installments which had been agreed in the arrangement. In such a situation, it's possible to start a special proceedings for changing the arrangement. However, it's a very complicated and it's very, I think, expensive for farmers, because it should be paid remuneration for the trustee and for the special administrator who is appointed by the court. And I think in such situations, it could be much easier to provide the possibility for the debtor to make a special statement in order to suspend paying installments, for example, for half a year. In fact, the proceedings which are designed to amend the arrangement last much more time, but half a year. So in such a situation, if we could provide the very simple institution of suspending the installments, paying installments, it could be a very good idea, which could help debtors who are in trouble after concluding the arrangement. Due to the studies based on concrete cases which are conducted by some of the universities in Poland, the conclusion is the following: that the bankruptcy dividend is relatively about 5 to 8% of the total claim of the creditors. In such a result, there are so many problems with economic equivalence of the proceedings. So the best solution for debtors is starting restructuring proceedings, which could be much more effective. In such proceedings, there is no selling out of estate of the debtor. It's possible to allow the debtor to continue commercial or agricultural activity and to go on with such activity during the fulfilling the arrangement. The assets of the debtor are not sold out, and in this respect, he has means in order to earn money to pay off his liabilities. In fact, the problem is with a very low, how shall I put it, with a very loud conscience of the farmers of possibilities which are connected with restructuring proceedings. So I think that we should start with a special campaign for farmers, which could explain the rules of arrangement, which could explain why it's a better solution than enforcement proceedings and why it's a better solution than bankruptcy proceedings. And I think there are some proposals which could help farmers to get to better conditions thanks to restructuring proceedings. There's also another idea which could be discussed, and I think I'd like to work hard on the project of such a regulation. If a farmer is bankrupt, he has to give to the trustee all his property and agricultural holding. I think it could be possible to change the position of a farmer who is the owner of the agricultural holding to the farmer who is a tenant of the agricultural holding. In this respect, a special state fund could buy from the trustee the agricultural holding of a bankrupt farmer, and if the farmer is a responsible entrepreneur, the state fund could lease the agricultural holding to the farmer in order to allow him to continue agricultural activity. In this respect, a lot of things changes because the farmer is no longer the owner of the agricultural holding, but in this solution, I think he could start his agricultural activity as a tenant of his previous estate, which he owned before the bankruptcy. This idea was very I think it was very interesting for listeners. I've discussed this problem with some specialists connected with insolvency, and I think it could be a very good idea to present for the protection of farmers. Well, I can recollect some more ideas right now. I think that the other problem is connected with the possible serious financial crisis. During the pandemic times, we had such examples of what happens if the court does not work. And in case of any financial crisis, which could come because of financial problems in the global finance, it could be, of course, caused by much more difficult problems. I think that we should start thinking about the special proceedings which could deal with not only one debtor but with the group of debtors. In fact, in the present regulation, we have such a very simple model. There could be only one debtor and many creditors. It's the essence of the bankruptcy and restructuring proceedings, that there is only one debtor and many creditors, because in such circumstances, it's a very good idea to deal with many creditors of one debtor. But these proceedings are very expensive. They take a lot of time for the court to deal with them. And I think we could think about changing such proceedings in order to allow the court to cover not only one debtor, but many of them who have the similar situation in case of their liabilities. And I think it could be a very big change of philosophy of bankruptcy on insolvency proceedings. But I think that in case of very special situations, in fact, in case of financial crisis, which will be a worldwide problem for many commercial markets, such proceedings which could help many creditors to be under special treatment at the time, I think it could help. It could help much more for the judiciary system in order to deal with the problem very quickly. And of course, there are some more ideas, but I think it will be better for me to get to my presentation, and next time I would like to continue this problem. And at the last seminar, I would like to come back to the problem of civil protection of farmers, because there are some topics which had not been mentioned by me, and I think they are much more important than even regulation of a farming contract. So I hope to continue my presentation next time. I'm awfully sorry for this case that I couldn't get control over my screen. The problem probably is connected with a very poor internet connection. Sometimes it happens. I'm sorry for that. I hope next time I will be in a better technical condition. Thank you for your listening to my presentation. Thanks a lot.
Dear Professor, thank you so much for your contribution. And now I would like to provide this opportunity, that is to provide deliver his presentation for Dr. Czirski.
Thank you. Thank you very much. Can you hear me?
Yes.
Okay. And can you see my presentation? Okay, thank you. So last time I started my presentation with some basic insights on the freedom of contract concerning agricultural products, and I presented also presented some insights about the legal forms that may serve as a basis for conducting agricultural activity. And in this presentation of mine, I would like to continue the presentation of my research with some contract law provisions and insights, and I will deliver a presentation on two aspects of contracts, specifically related to agricultural producers. As you can see, there are two parts in the presentation. The first one will deal with the contract law provisions that are codified in the Hungarian Civil Code, and it is quite unique. But the Hungarian legal system has also some contract law provisions in, I would say, public law legal acts, such as the Agricultural Markets Act, which is of public law nature, but tries to complement some provisions that are codified in the Hungarian Civil Code. In the Civil Code, there are two sector-specific sales contracts concerning agricultural producers. These two contract types are subtypes of the sales contract. The difference between them is whether the buyer contributes to the production or not. So there is the sales contract, which is concluded for the provision of self-produced agricultural goods, and there is another type when the sales contract is a little bit more than the first version, because the buyer, to more or less extent, also participates in the production method. These two contract types are complemented by the provisions of the Agricultural Markets Act, and in Section 4, the Agricultural Markets Act declares that before harvesting, only these two above-mentioned types of contract can be concluded with an agricultural producer as a seller of agricultural products that is produced on the land and that is used by that agricultural producer. So there is an obligation for market participants to use these contract types if the conclusion of the contract takes place before harvesting. The first one that is codified in the Hungarian Civil Code is the sales contract, when only the agricultural producer is the one who produces that product and does not use the help of the buyer. And there are two quite important sector-specific rules, and the first one is that the seller undertakes to deliver at a later date agricultural produce, products or animals of his own breeding or fattening, but he is entitled to deliver 10% less than the quantity stipulated in the contract. And if this happens, the performance of the seller, the agricultural producer, won't be qualified as the breach of the contract. Furthermore, the seller is entitled to perform before the stipulated time for performance, provided that the buyer is notified in advance of the commencement of performance by giving him the time necessary for preparation for taking delivery. The second provision tries to cure the anomaly that for certain producers there is no storage capacity to store the products that have been produced by him, and it opens the possibility for producers to perform the contract before the stipulated time determined in the contract. The other type of sales contract is a little bit special, because in this case the buyer also participates in the production method, and because of this there is a provision also for the seller, for the buyer that gives him some protection. And but first of all, if not only the seller undertakes to supply at a later date an agricultural product or a product of his own production, or an animal reared or fattened by him, but also the parties agree that the buyer will provide a service to facilitate performance and supply the seller with information relating thereto, the seller is obliged to use that service in accordance with the information. That is to say, there is an obligation for the agricultural producer to make use of the service that was provided by the buyer. And it is really important that the seller is obliged to pay the contract price for the buyer's services in support of performance, and to repay the part of the production advance paid by the buyer not covered by the purchase price, even if the production result does not cover it. That is to say, if anything happens and the agricultural producer is not able to perform the quantity or the quality that is stipulated in the contract, but the producer used the services of the seller, of the buyer, in this case it must repay and pay the price of these services, and it cannot happen that the seller's services are not covered in any circumstances. And there is another contract type in the Hungarian Civil Code, which is not a sales contract but a service contract, I would say. And it declares that under a contract to perform an agricultural work, the producer shall rear an animal owned by the client or produce crops on the land owned by the client, and the client shall pay the fee to the producer. So it is quite unique that the producer is like an employee, and he doesn't own the land, and he doesn't own the animal that will be reared by him. And in this case, the producer shall not be liable for the contract that has become impossible to perform due to an animal or crop disease, if the reason for this disease was outside of the producer's control and it was unpreventable. In this event, the producer shall be entitled to a pro rata fee. That means that the producer will be paid by the client, but as a pro rata fee. That means he won't be entitled to the full service fee, but only part of it. And another important provision, that the producer shall not refuse to refund the services provided by the client for settlement or as an advance payment, on the grounds that these cannot be covered by the results of the production. These provisions in the Civil Code are complemented by the Agricultural Markets Act, and moreover there are further contractual provisions in the Agricultural Markets Act, and many of them is in connection with payment deadlines, while the other with the requirement of certain contracts to be in writing. And furthermore, there are certain provisions applying only to some subsectors of the agricultural, for example, apple, sour cherry, horseradish, and sugar beet, as well as fresh and perishable fruit. Concerning the payment deadline, the basic provision is that no more than 30 days from the date of the delivery of the goods, provided that the invoice, if duly drawn up, is sent to the processor, the collector, or the distributor within 15 days of the date of the delivery. If the correctly issued invoice is made available more than 15 days after the delivery, then the payment for the goods must be made within 15 days of the receipt of the correctly issued invoice. And if this requirement is not met, the debtor is obliged to pay the price of the product with the interest on arrears specified on the Civil Code, but at least twice the base rate of the Hungarian Central Bank. And as you can see, this last provision provides a further protection pillar for the producer, that if the farmer does not receive the payment in time, he will be paid. He will be paid with interest on arrears, and it has a minimum amount, which is at least twice the base rate of the Hungarian Central Bank. And in this inflationary situation, it is quite a lot of interest. Concerning the payment deadline, there is a further protective pillar for producers, which stipulates that the sales contract between the producer and the processor or collector shall include a provision in which, in the event of late payment, the debtor, that is the processor or collector, gives its consent or authorization to its payment service provider for a direct debit mandate covering both the price of the product and the interest on arrears. That is to say, the payment service provider, the bank of the buyer, will be able automatically to send the payment to the farmer, and because the contract that was concluded before performance stipulated the authorization, and it's an obligatory element of the contract that no contract can be concluded without giving authorization by the buyer to its payment service provider. So it's a further protective pillar for farmers. There are many requirements, and there are many subsectors where written contracts are a requirement, and it comes from the possibility provided by the Common Market Organization regulation. For example, contracts for the sale of raw milk, and this comes with further requirements, such as that the duration is at least 6 months of this contract, and if indeterminate duration, if the contract has indeterminate duration, the termination is at least 6 months. And as well as sour cherry and apple have some requirements concerning written contracts. If imported to Hungary as basic products for processing, as well as horseradish shall be contract sales related to horseradish shall be concluded in writing. It is important that these contracts shall specify the price to be paid as a static that is set out in the contract, or as calculated by combining various factors set out in the contract. These provisions are in line with the Common Market Organization regulation, but the member states are not required to use these provisions, but Hungary aims to protect the farmers with some contractual further pillars that protect their negotiation and make use of these possibilities created by the Common Market Organization regulation. In certain cases, there are deadlines to conclude a given contract. For example, contracts for the purchase of at least 60% of the fruit to be processed by the processor in a given year shall enter into force by the 15th of May of that year in case of sour cherry, while by the 1st of August in case of apple. These deadlines shall not apply to processors who process not more than 100 tons of sour cherries or 200 tons of apples in a given year. So there is a de minimis provision, but in general, there are some deadlines to conclude the sales contract in this subsector. It also applies to horseradish, that contracts shall enter into force also by the 1st of August. And also there is an exemption that it shall not be applied if the horseradish is sold directly to consumer or in a wholesale market. Concerning defective execution, there are some protective pillars for producers. For example, no quality objection can be raised in respect of fresh or perishable agricultural and food products sold between the producer, processor, purchaser, and distributor after the expiry of the storage life or the date of minimum durability laid down in a written contract between the parties, or in the absence of such contractual provision after the product has been taken into their possession. It aims to protect farmers in a way that if the buyer is not able to sell or I would say resell that product, then it cannot take it back to the producer. Of course, this decreases the vulnerability of producers, especially in the fresh fruits markets, by excluding late quality complaints based on which producers would only receive the value of the goods at a reduced or zero price or with delay. And in my next presentation, you will also see that this conduct is also stipulated as an unfair practice, but I will speak about it in the next presentation of mine. It is important to mention that in certain cases, if buyers take over the goods at a reduced or zero price, but process or resell them, on one hand generating profit from it, and on the other hand creating price pressure on goods of high quality, are also arguments that must be taken account for the sake of protecting farmers, which is quite interesting, and I would say that is a good practice, and I would like to emphasize it, that in Hungary certain contract law provisions that are obligatory to use by the contracting parties are enforced by public authorities. That is to say, the producer has more than one option to enforce the contractual provision, and the farmer cannot only go to a private court, but also there is some danger for the buyer that he will be fined by an enforcement agency if he doesn't meet the requirement determined in the Agricultural Markets Act. And these provisions are supervised by the National Food Chain Safety Office and the county government offices, and in the event of a breach of any of these obligations, a fine between 10,000 and 50 million Hungarian forints can be imposed, which, however, cannot exceed 10% of the net turnover achieved by the infringer in the business year preceding the decision that establishes the infringement. This 10% maximum amount is the same than the one used in competition law and competition enforcement. And I think this is a very forward-looking provision that accepts the fact that farmers are to a certain extent influenced by the so-called fear factor, which means that the producers are afraid of taking the necessary legal steps against their buyers because they fear that they will be excluded from certain economic transactions, and they won't be able to negotiate with that buyer once again, and they cannot risk that they lose a valuable bargain for them. So it is quite good that a public enforcement agency can step into the picture, and it can be used as a protective authority to help farmers operate in a more comfortable market situation. Thank you very much for your attention.
Dr. Czirski, thank you so much for your presentation. And now my question is whether do you have a question to each other? Of course, in this case, I would like to provide the opportunity or any comments. Dear Professor Adamus, please.
I have one request to you. I'd like to get your scientific papers you mentioned during your presentation. It was too fast. I had no time to write down the sources of them. Could you send me, please, your articles?
Sorry. Who was the addressee of your question? That is Dr. Czirski or me?
You were, I think.
And the question was the...
I'd like to ask you for sending me your scientific papers you prepared and presented during your presentation.
Okay, I can send at this moment, of course, the PPT only. And if you want this, of course.
Yes, please.
Okay. Other questions? If not, in this case, I would like to draw your attention, first of all, as I previously mentioned, that in July, we have another meeting, another opening seminar. It is on 26th of July, as far as I know, maybe at 4 o'clock p.m., but I check it, whether is it the situation or not. Moment. Yes, as far as I know, therefore, 26 at 4 o'clock. Another important issue, but please do not forget that after that, during August, you should send your first contribution, that is the chapter into the monograph. Please do not forget this deadline. Please do not forget that beside presenting the given legislation and practice of our countries, or as the subject of our chapter, we also have to focus on best practices and the de lege ferenda proposals. They are important issues to determine these proposals. My plan is that if you send your contribution, the chapter, I would like also make a kind of reflection. For example, if there is a lack of the proposals or de lege proposals, in this case, of course, I'm going to draw your attention that please do not forget to add this kind of proposals. Dear colleagues, I do not know whether you have any questions in connection with this issue or not. But if not, in this case, I would like to express my gratitude that you were here, and I wish you a nice evening. Dear colleagues, have a nice evening and see you later.
Thank you.
Thank you.
Thank you very
Goodbye.
much.
Bye.
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 Thank you. Goodbye.